Mention.
Please, Your Lordship. I beg to mention item number 60 of the hearing list. This relates to that registration of the excise label, my lords. Lordships, we informed Your Lordships that the division bench of the Honourable Bombay High Court had dismissed the appeal, had allowed their appeal and dismissed our injunction. We've already preferred the SLB, my lords, and this was on caveat, so they've received a copy.
We've not received a copy as yet, but we are conscious of the fact that they've filed a...
It's already been filed. No, it's just been filed, my lords. We have the diary number.
So what should we do?
Kindly have it after 2 or 3 weeks, my lord.
On a prayer or something? Yes, let's after 3 weeks.
Obliged, my lord.
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 68, Your Lordship. Your Lordship, I'm praying for 2 weeks' time, Your Lordship. No objection, Lordship.
Why?
The conducting counsel is having some personal difficulty, Your Lordship.
Yes.
Highly obliged.
More convenient difficulty than personal difficulty. It's convenient, attend. Not convenient, don't attend. Right? Yes.
May it please, Your Lordship. I beg to mention item number 55 and 56.
55, 56. Yeah. He's still in bereavement?
No, Your Lordship. He's out of station, Your Lordship.
Oh, Mr.
Paske.
Okay.
No objection, Your Lordship.
2 weeks.
Obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 67, Your Lordship.
Where's the petitioner?
I'll inform them, Your Lordship. I've not seen them.
No, you inform them first.
Okay, Your Lordship.
That's a convention in this court.
Obliged, Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 59, Your Lordship. 59, Lordship. The senior counsel is having engaged in part and matter, Lordship.
Objection.
Yes.
Lordship.
Number 2.
Lordship, I beg to mention item number 61.
Yes.
Yes, the matter may come up after a week, Lordship.
No objection, Lordship. Lordship, 61.
Lordship, 62 and 63 are connected matters with 61.
62 and 65?
63, Lordship.
So they also go?
Yes, Lordship.
No objection.
Yes, okay. 2 weeks.
Must be.
Yes.
Lordship, I beg to mention item number 58, Lordship. This is joint request, Lordship. 1 week. 58. 58. This is Nokma matter, Lordship.
Yes.
Must be.
Lordship, I beg to mention item number 64, Lordship. I'm praying 2 weeks' time, Lordship.
Supplementary list item number 1.
My Lord, this is non-compliance of order at page 13, my Lord, 25/9/2024.
Where's Dr. Mozika?
This is pertaining to ciphers, my Lord, again. This again originates from...
Not implemented till now.
My Lord.
They have preferred an appeal.
No, my Lord.
Against the order.
No, my Lord. The other order that your Lordship had passed, that, my Lord, did not go for appeal, but then they sent it to the Ministry of Finance. Ministry of Finance recently, my Lord, have said that it is already a covered case, you take a decision on it. Now, no decision has been taken.
Yes. I've heard Mr. B. Pathak issue notice, returnable in 2 weeks. Steps have taken by registered AD within 2 days. Yes, just accordingly on so and so. They don't know what they want to do these matters. That's the main reason.
My Lord.
Item number 2.
Deeply obliged.
Come like a monster. What is this?
My Lord, I'm challenging an order passed by the DC Revenue, my Lord. Here, the petitioner, my Lord, he was doing construction in his house, my Lord. at Upper Shillong, my lord.
Construction inside his house?
No, my lord, in his own land, my lord. At Lumpedang area, my lord. And what has happened is, my lord, some police personnel from Jhalupara outpost as well as some personnel from the Deputy Commissioner's office, my lord, they have come before the they have come in the site of the construction site, my lord, and thereafter they have asked the people who are working there, my lord, to stop the construction and not to do it, my lord. And thereafter, my lord, the petitioner has approached the Deputy Commissioner's office, stating that he is the owner of the plot of land and he owns.
Did he serve any notice or something?
Till that time, my lord, there was no notice given. And then when we have approached the Deputy Commissioner's office, my lord, we have given a letter. That is at page number 13, my lord.
Yes.
We have given this letter saying that we own this plot of land. I'll just read out, my lord. Subject is illegal obstructions by members of your office or police personnel. Yes.
Yes.
It says, my lord, with reference to the subject as
What was the reply?
My lord, after that, my lord, they have issued a letter that is at page number 14, my lord. 7th August 2025. They said immediate stoppage of ongoing unauthorized construction.
You are constructing on revenue land?
No, my lord, that is not correct. This is my own plot of land, my lord. And yesterday, my lord, they have come and put the signboard again, my lord, in the just in front of the building, my lord.
How do you come into possession of this land?
My lord, I have purchased this plot of land, my lord, may kindly see. Page number 10.
Where have they put this signboard?
Just outside the boundary, my lord, in the road.
This is your construction?
That is my building, my lord. And building permission has already been obtained.
I don't know whether it is writ remedy or not for you.
Now, my lord, may kindly see page number 10.
Yes.
Lordship, they should be approaching the concerned authorities, Lordship, here, and this will be disputed facts here.
My lord, may kindly see page number 10. This is the sale deed, my lord, by which I have purchased this plot of land, my lord.
Registered?
No, Lordship.
No, my lord, that is not registered. However, again, my lord, page number 11, if my lord will see.
Yes.
It says this is given by CM of Millim, my lord. It says this is to certify that the landed property situated at 3rd mile, Upper Shillong, having the following.
Kurkalang area, there is a big dispute. Where is forest land? Or...
Yes, we have purchased from that.
But even it's common knowledge that these suits have been pending for.
Yes, however, my lord,
number of years now.
I am not party. I am not party to the suit also. Plus,
happily selling land while the suit's going on.
Now, my lord, we are not party to the suit also.
So you're a victim.
Yes.
Not a party or victim to the
suit. And moreover, when the suit is pending, my lord, there should be some order from the court, my lord, to stop me. Now, one of the party who is also there in the civil suit, my lord, they are coming and, my lord, taking illegal possession of the plot, my lord, and they are
selling it.
Yes.
So you also you were duped by them.
Yes, my lord. May kindly see. I have already invested so much of money, my lord.
Then you have
work
to seek a remedy against those people who
Lordship,
sold land.
I am agreed by the order passed by the Deputy Commissioner, my lord. When the suit is pending, my lord, it is not correct for the office
then
of the.
Then you have to implead yourself in the suit.
No, my lord, it is not correct. Without any order of the court, my lord, they have tried to extrajudicial means, my lord.
File a supplementary application for injunction.
For the time being, my lord,
you have enough civil remedy, Mr. Sinkon.
Now, my lord.
Now, in which way do you expect orders from this court to allow to continue construction?
No, unless, my lord, there is an order from the civil court, my lord. This order passed by the Deputy
Commissioner, your luck,
my lord,
I understand.
That is not correct.
You take instructions. We'll give you that much at least notice. But no construction, because this is common knowledge. You have heard Mr. Ensinkon, learned counsel of the petitioner issue notice. All respondents.
All, Lordship.
You didn't make the person who your vendor party.
No, my lord.
Right?
My lord,
that means
because my remedy is against.
Also it's
I am seeking relief against the Deputy Commissioners, my lord.
What's a necessary party in a formal party?
Main party will be the vendor, Lordship.
No, if it's not necessary party, it'll be
My
formal
lord,
party
I
also.
only agree by the order passed by the Deputy Commissioner.
You're seeking to establish your right from a document which is executed between you and person X, correct?
My lord.
Then isn't he a necessary party to come and say that yes, like I have like good title to the property that I've sold to the petitioner?
I can arraign him as a party.
And the thing is that the interruption by the is without any basis. Mr. John, otherwise we'll dismiss
I'll add them as a party, my lord.
I will dismiss it now.
No, my lord.
Lordship is not maintainable, my lord.
My lord, for now, my lord, let the notice be issued. We'll implement
No, you don't want to complicate matters.
Because alternate remedies are available to the petitioner.
Moreover, my lord, I am only agreed by the order of the Deputy Commissioner. They are not right, my lord, issuing this order when the civil suit is pending, my lord. My lord, it should be by an order of the court, my lord.
Why am I arguing with you? I don't understand. But you impede yourself. Anyway, you take notice. So issue notice. MS Anjisla Series of so assembled on behalf of all the respondents for the notice required. Just after 3 weeks. Yes.
Apply, Lordship.
Item number 3.
Who is representing this?
Respondent 4 will file affidavit, my lord.
Get ready in the matter.
So, my lord, Lordship kindly sees the affidavit of Respondent 4, my lord. Lordship kindly comes to page 19, my lord.
The affidavit filed by respondent for the bring on record added material.
Yes. Yes, my lord.
Yeah, what does it say?
Page 19, your Lordship will see.
Yes.
Well, he has been charge sheeted in the FIR, my lord, for misappropriation.
Where is that?
It starts from page 14, my lord. This is the charge sheet by police.
This is the charge sheet. Respondent number 4 supporting your case.
Basically. Yes. Basically. And page 19, establishment of offence.
Yes.
The alleged accused person, Sri so and so, was found to have committed.
Kambalang Hasandi is Mr. Linga.
Yes.
Committed dishonest. No, this is a complaint petition. What is this?
From page 14, Lordship will see.
This is what?
This is final form report.
Okay.
It's submitted by police, my lord, page 21, the signature. Now, my lord, coming to the Adong, my lord.
Coming to?
Page 247, my lord.
So that's all evidence collected. Is found a case under 403 is well established against the alleged accused person. Okay. Yes, then?
Now, then, my lord, page 247.
How does affidavit?
Yes, my lord.
You must say 247 pages in this affidavit.
Which one? It's bulky only because of the Adong is translated in next one.
Yes.
Page 247, my lord, the last row, my lord. The responsibility and duties of the headman.
Yes.
The responsibility and duties of the headman are as follows. This is number 3, my lord. The headman is prohibited from misappropriating the funds of the village.
As if this will be permitted. What kind of Adong?
This is put in writing, my lord.
No.
This is codified, my lord.
This is too funny. It's proper, as if anyone can misappropriate funds. This is not right. Yes, anyway. So that is there.
My lord.
Okay.
So, my lord, as we stand today, my lord, he is a headman who has just been disqualified. Though Act nowhere says that a disqualified person cannot recontest matter.
Can you apply analogy of general election law to such circumstances with regard to eligibility?
Because what will happen, my lord?
We have to apply the common standard. Can we have different standards now? Because this is okay, might be customary office to a traditional post. But the thing is that can we have extra conditions? In general elections, even a person who's incarcerated also can contest. Right.
Now, my lord, if Lordship sees the act, my lord, the new act.
But the thing is that because the district council last time, I think, they had said that there's something wrong. It's not right.
My lord, last time it was not very properly worded. It said, my lord, who acted against him, my lord, number one, and who litigated against him.
Yes.
So litigated, I admit, my lord, that cannot be a condition.
Cannot be a condition.
Litigated cannot be a condition, but acted against the interest of him, my lord, and when there is a charge sheet against him, he faces, and his removal has attained finality, is never challenged that, my lord. So, my lord, what will happen? Just 6 months back or 1 year back, he was removed. He comes back, my lord, to the headman. Then again we remove him. Again hold election. Then again he'll participate, my lord. This will never end.
The election results under seal cover.
Are under seal cover.
He didn't take part in elections.
No. He did not even come to take the nomination paper also, my lord. He's only taking chance of frustrating the elections, my lord.
He came to challenge to conduct.
If his conduct was even before the court, so he used to come through proxy litigation.
Proxy litigation, my lord.
That is so, right, Mr. Lingdo? On 2 occasions.
Only in one occasion.
Twice.
Lordship.
Even to the memory of this court.
Lordship, in the first litigation through the sort of Nokshong, I was also one of the petitioner approaching before your lordship.
Not this Cumberlong. They were espousing your case only.
Petitioner number 2 in the first round of litigation, your lordship. I've approached your lordship in that manner. So, your lordship, by
first round of litigation,
number 1 is an unregistered organization for the reason, your lordship, and since at that stage the KHADC, they have already taken cognizance of the appeal filed through the Sotki Nokshong, and so I have brought the record, your lordship, in my affidavit.
No, it's okay.
But the only thing I wanted to point out again, my lord, in the new act that is coming into effect now, my lord, section 14 of Lordship kindly sees, my lord. If Lordship has that.
Next year.
It was placed at Mavlang Act, my lord, 2023.
Yes.
Section 14 of Lordship kindly sees, my lord. Qualifications of a Rang Vaishnav.
Section 14.
Yes, my lord.
Yes.
Now, qualifications of a Rang Vaishnav, my lord, I am referring to clause 4, my lord. He bears a good moral character who commands social respect in a village. Good moral character, this directly impinges on his moral character, my lord. A person who is charge sheeted, who is removed from his post. So, my lord, if Lordship directs the HEMA to reconduct the elections also, my lord, the election committee may be given the power to scrutinize the nomination.
Who will be the person who will judge his character?
There'll be a committee, my lord.
Let there be an election. Let them participate if the people decide if he's fit or not.
First scrutiny, there will be an election committee of the HEMA, my lord.
No, correct, but then let the people decide. Otherwise, you'll be stuck in a deadlock like this. Yes. Because even that condition that was put, that he is litigated and acted against, that is too general. That's too general and generic a term to.
My lord, to that extent I admit, my lord. But a person, he'll be disqualified on this also, my lord.
Then you can put this, if you find nominations, you can place objection. At that time, the opportunity given to.
But that's for HEMA to do, because I'm only a candidate, my lord, who participated.
HEMA has to place that before the legislative committee, that the Adong is like this, that he has acted against, and there's a final form report also. So whether he's a fit candidate or not, let him decide.
Even the lordship, I'm also one of the contestants interested for the post.
You're interested. That means when you file nominations, be objection, they be allowed to reply to objections.
Charge sheet has been filed, lordship. I am not guilty until proven, lordship. Trial needs to be conducted.
See, Mr.
removed candidate.
You will be allowed to take a resolution form. You file it, and as in any election process, when the scrutiny is going on, they'll object to your on the ground of being ineligible by operation of section 14(4). So then the election committee will take a call on that.
Lordship, I would agree with your lordship if the election process be followed in accordance, lordship.
Of course,
then be adopted, lordship. Otherwise, even a person languishing in jail, if he's fit to contest the election, lordship, he's fit to file nomination. So,
see, that is a different standard, but then this act is there. See, where let the people decide also.
The representatives of people like this as clauses are not there. The moral conduct.
Why even intimidate the electors?
Well, he has a lot of money. Well, he can do anything.
No, Lordship, see, that is the main allegation.
I can place on record the YouTube video.
They have resort to statutory relief as well, Lordship. In accordance with other.
While you resort to monetary relief.
No, Lordship. In my affidavit, Lordship, I have relied on certain documents which I have placed before your Lordship also in the previous.
In fact, from the district council side on the first round of litigation, I had said that let the district council conduct the election, so that both the parties, it appears that they're really at enmity.
Act provides for him to.
But then the same.
No, after you undertaking a single bench that we are not capable to conduct election. That's what he response number 4. Going filing appeal and still never meet a submission.
Yes, that was very.
It's not in good form.
But now the new act is in place, man.
Fine. So we are as per a new act.
Fine.
Your Lordship, if it may, an observer also be appointed to observe the entire process of the election.
Observer company elections are in the field, but at the time of what observer scrutiny?
They'll be subject to judicial review. If
Observer can be there, but he can't. Observer means he can't interfere. Observer will sit in the corner. He can't interfere in the proceedings of scrutiny or final nominations.
Yes, Your Lordship. Your Lordship, it'll be a little bit fair and democratic on this election process.
Let the council conduct elections then.
Yes.
No.
But the act is very specific. He might to conduct election.
Fine.
So we are ready to conduct election. The main thing is that during the time of this election, now Your Lordship, respondent number 5 has come. He has come to the HEMA at the time when we have released. We have announced the date of releasing the form, filing the nomination, taking the nomination form for date of scrutiny and the date of election. He had come to the office of the HEMA along with few people. He came and saw the conditions and he left. He
did not collect nomination form also?
No, he did not collect. He never filed also. That's why we were never given a chance. Had he filed a nomination, it would have gone to the scrutiny process. Then at the time scrutiny, we will have passed. Like what the senior petitioner has submitted, that we could have given the reason why. We could have stated.
Or could have allowed also, don't know.
Because at that time, the new act has not come into place.
No, just come again. Now, you mean to say at the time of election, it's not that his nomination was rejected and he filed a appeal. No.
He never filed a nomination.
What happened, the circumstances was that I was supplied with the condition. Immediately on supply of the condition number 4 imposed that anyone who litigates against.
So you could not.
I'm the one here, Your Lordship. I'm the one.
Your Lordship.
Litigating against the HEMA, and they are saying that. So it's obviously, Your Lordship, at that point of time, upon scrutiny, my nomination paper may be rejected. Now, Your Lordship, we are looking at a fresh issue now. The entire matter.
No, not so. That means you are sure your nomination will be rejected. Yes, that stands to reason.
Apprehension is there, Your Lordship. And now, Your Lordship, with the new act, Your Lordship, upon me now, if I do not take part in the election process of filing of nomination, it's upon me now. But I'm willing to take part entirely if any other candidate...
will dispose in that manner.
Well,
if there any other interested candidate, Your Lordship, will take part. Let the people decide.
Yes, you hear order. Take down. The instant writ application is directed against the impugned order dated 9/5/2025 passed by the respondent number 2 bracket Executive Committee KHDC in political appeal case number 2 of 2025, whereby a certain clause, namely clause 4A of a letter issued by the respondent number 4, which disqualifies candidates who have acted against or have litigated against the HEMA. Problem? has been declared void as null and void. Stop. The case of the writ petitioner is that elections to the post of headman of Kleshnong had been conducted on 18/3/2025, and in view of the impugn order, whereby the said clause was declared null and void, directions had also been issued for conduct of fresh elections. Next paragraph. It is submitted by Dr. N. Musika, Learned Senior Counsel, on behalf of the petitioner, that the respondent number 5, who had preferred the particular appeal, is ineligible to contest for the post of headman of Mongap Kleshnong, in view of the fact that he had earlier been removed from the post by the respondent number 4 on allegations of misappropriation and defalcation of village funds. Stop. Learned Senior Counsel submits that the matter has also resulted in a police case being registered, wherein the respondent number 5 has since been charge sheeted. Therefore submits the impugn order impugned, setting aside the said condition, is unjustified and will result in a person with questionable moral integrity being allowed to contest for public office. That is of headman. Stop. Next paragraph. Mr. T.D. Learned Senior Counsel, on behalf of the District Council respondents 1, 2, and 3, submitted that the Executive Committee, where's the impugn order?
Which 45?
45.
The impugn order.
46 is the
imp order passed a political appeal, dealt only with the criteria that had been prescribed for being qualified as a candidate for the post of headman, and that in the considered view of the Executive Committee, clause 4, which disqualifies individuals on a ground of acting or litigating against the HEMA, appears to have been inserted with the intent to exclude or bar the appellant from filing his nomination papers, and that further the condition also militates against the provisions of the Nadir Khasi Jante Hills Autonomous District Appointment and Succession of Chief Headman Act 1959. Stop. Learned Senior Counsel further submits that there should be no bar unless a person is convicted from contesting for public office, even if it is an office of headman. Yes, number 4. What do you have to say? Mr. Sorry, your name again. Yes. On behalf of respondent number 4, has submitted that the respondent number 5, before the last elections, had not even filed or seek to file, or had not filed or tried to file the nomination, but instead had filed a particular appeal case number 2, 2025. You didn't appear there. You represented.
Yes, we have to. We have filed our written reply.
Yes. Thom, had even sought or tried to file nomination, and so another council submits that had the respondent number 5 filed nomination, you would have given the election committee an opportunity to study his nomination papers and to declare whether he was eligible to contest the election. That is submission, correct? Yes. Respondent number 5, what do you have to say?
Your Lordship, I may be, as per the allegations, whatever Your Lordship, as per the materials that I've brought on record, Your Lordship, with respect to misappropriation, in the previous proceedings, which I have brought on record again, Your Lordship, the money has been given to the respective owner.
Okay. Next paragraph, Mr. S. Alindo, on behalf of respondent number 5, submits that though charges have been made against him, or allegations and charges made against him, the same are baseless, and it's not a fact that the writ petitioner had misappropriated any amounts. So he further submits that, be that as it may, there is no bar existing presently that should prevent the respondent number 5 from contesting in the election. Stop. Next paragraph. This having heard the counsel for the parties. Oh yes. Stop before that. Mr. Titi Lindo, the counsel, after submissions have been concluded by the respective councils, has apprised the court that in the with regard to Boplang Lingdoship, an act, namely the Khasi Hills Toronto District bracket nomination and election of Lingdo Menteri Bakrao Bashnong Sonsu 2023, has since been notified and has now been implemented by the district council. He submits that should there be a fresh election, the same will be in accordance with law and as per the new act of 2023. Stop. Dr. M. Mozika, to this submission, has also drawn attention of this court to section 14.4 of the act, which prescribes that a candidate must bear a good moral character and command social respect in the village to be eligible to contest. Next paragraph. Having heard the counsel for the parties, it is seen that the main issue is with the resistance of the respondent number 5. And the petition and the respondent number 5, who is the chief of
respondent number 4 is the chief.
4, sorry, resistance of respondent number 4, who is the chief to the participation of the respondent number 5 due to the allegations which are pending against him. Stop. Further, it's also noted that the impugned order on a detailed perusal does not suffer from any infirmity, inasmuch as much infirmity in the finding that the criteria that are prescribed, that is clause 4, was violative of the Act of 1959. In this backdrop, therefore, and with the introduction of the Act of 2023, in the considered view of this court, the interest of justice would be served if fresh elections, as ordered by the impugned order, be conducted by the respondent number 4, taking into account the Act, as also the Act, as also the, what else you are taking into account? Because next you want the procedure to be, should we give the directions as to the procedure to be adopted? No.
I don't think that's required.
No, it will only be see, the elections will be a 4, but there'll be executive member or maybe an officer deputed by the committee he'll be there at the stage of scrutiny and at the day of election.
Yes, that would be a better.
Your Lordship, impression in accordance that it should bear a good moral character is already having a little bit of effect on the entire issue. You know, it may be reflected the pendency of the suit does not bar.
Not so criminal.
No, you said that the fresh elections you will be allowed to participate, and then in scrutiny, only thing the court will say that fine to ensure that fairness, that you also feel that okay, it's a fair process. They'll this council deputy officer who will be there.
That's
not an observer, correct?
That's an observer.
Yes.
That's an observer.
Yes. And in interest of justice and fair play, yes. Number 4, stop. The said election process from the stage of scrutiny and also the date of the voting shall be I will not say I'll not say what word to use. Is directed that the executive committee shall depute also an observer
At the time of scrutiny.
At the time of scrutiny, and also at a time, of course, to ensure
free and
that
fair.
the proceedings are free and fair and held in accordance with law. Yes. The respondent 4 to accordingly intimate the new date of elections or new schedule. Yes. Within
at least 1 month.
Within 4 weeks. Yes.
With the conditions, Malik. They'll notify the new election with the conditions. What are the eligibility conditions? They'll notify with that.
Let them notify it. We're not going to prescribe.
As per the Act, as per the new Act.
As per the Act, yes, in accordance with law. Yes.
In accordance with that.
Yes, petition upon his stance disposes.
Item number 4.
Sorry, Your Lordship. Yesterday is striking that. So, this is the instruction, Your Lordship.
You given a copy?
I don't have a copy.
We can close it.
See, Your Lordship, some problem has come up.
What problem has come up?
This pension paper again to resubmit.
What is this? What problem?
This is the matter has come from 14/7/2025 from this CDA pension. So this
you can't do this. A person is disabled and you're raising these kind of. What disability she is suffering from?
He's suffering from
Yes.
He's suffering from schizophrenia, and my lord, a part of that also his right eye. He has a disability in his right eye, my lord.
No, yes. Since when he's had this condition?
Since 3 years old, my lord, and that prescription also, it's there, and this
petition.
Yes, it's there in the writ petition, my lord, and with respect to that, my lord, the doctor who has given the medical prescription is also a part of the board of disability, which they have issued a certificate, my lord, and this is also the assessment which is done by the board, my lord. And with regard to
Mr. Devnath.
Yes.
I think you have to pay costs also. Is there in the writ petition that a person suffered from 3 years old? Does he have to prove that he was disabled at the time of his parents' death? You should know better when you ask for instructions and to apprise your people. Will impose substantial cost. Yes.
So you see, this observation has come from this CDA.
This is the reference. I mean, what have they given? Above mentioned prime pension claim has been received the examiner's end is observed disability has been issued on 13/9/2022 after the death of his parents. So a person suffering from mental disability from since he was 3 years old, parents died, now he has to prove again that he was disabled at the time of the death. At the time of the death.
So as per CC's pension rule, then follow the pension rule.
The thing is that once he submitted the disability certificate along with her claim, that should suffice. We will pass orders. I think we will impose exemplary costs. You cannot do this. You see, are these on record?
Yes, my lord.
In the writ petition?
No, my lord, that is not on record, my lord. But we have filed.
Tomorrow.
Yes, my lord.
Mr. Devnath has produced a communication dated 14/7/2025 containing the instructions received from the respondents. Approval of the same shows that the pension has not been released as the beneficiary has to show that he was disabled during the lifetime of the parents. Stop. Next part. It's not understood under what circumstances these instructions have been issued when it's already given in the disability certificate that the beneficiary is handicapped since the age of 3. Stop. Learned counsel was pressured to find additional documents in support of the claim. Just after 1 week, we'll pass orders then. This is very absurd.
Daily list item number 1.
Wait for a person to die before you give disabled certificate to a who lost both his parents and is mentally handicapped.
Highly obliged, my lord.
My lord, item number 1 to 41, my lord, was directed to file an application.
Where's the miss case?
Miss case, my lord, we are filing it tomorrow, my lord. They are coming today to sign it, my lord. Positively, we are filing it tomorrow.
The contempt may be closed because
no, my lord,
there is no point.
No, my lord. Let it come up tomorrow. My lord may decide.
File it.
My lord, we are filing it tomorrow.
Because we have to only for modification in the order. Why should
of the early order? Why should contempt also?
Because 41 people, my lord, they have to come from Bhulaganj, my lord. For that, my lord.
For the interest of the court or for
their interest.
One can file it.
We'll file it tomorrow positively, my lord.
You have to call in one person.
My lord, we are filing in each and every petition, my lord.
So we will not see anything.
Best left to the wisdom of
That's wisdom to counsel.
42.
Here I will pray for some more time, my lord. File my affidavit, my lord.
Yes.
Show me the petition.
Why?
My lord, we have not received the Paravis comment, my lord.
No objection.
No objection.
No objection.
You dare the matter, Mr. Nogri? Philip Shandin.
42.
This is a review, my lord. There is no error apparent on the face of the report.
What is seeking review of?
Review of the order.
Modification, alteration of the order.
Pursuant to the judgment of the
If my lord may kindly come to page 118, my lord. They have appealed my lord's order, and this is the order which was passed by the division bench, my lord, where they was allowed to, they was given a liberty to my lord to file a review, my lord. So they have filed a review, my lord.
Oh, okay. Yes. After 2 weeks.
Fine.
On the pre Mr. SD.
My lord.
So they got leave to review from division bench.
From division bench.
only liberty was granted.
Liberty was granted to file a review, my lord.
All rights open to question the maintainability.
Oh, okay.
43.
We have already filed. We have already filed our affidavit.
5, 6 and 7. Objections filed.
I'm hearing, my lord.
Objections not filed. Very good. Ms. M. Ramarat has entered appearance today on behalf of Respondent 4. Such notice complete all respondents. Complete now all respondents.
Yes, ma'am.
So you'll file objection.
Yes, sir. We'll file objection to the.
Yes. We'll file. Yes. Counsels for Respondent 4 and for Mr. Amara for 4 and Mr. Philomena brief for 5 to 7. Pray for allowed. 2 weeks time for objections.
44.
In this matter, the petitioner is supposed to file the rejoinder, my
I'm
lord.
praying 2 weeks time, Lordship, to file a
How many
rejoinder.
times you prayed?
This is third time, Lordship.
Okay, third and final positive granted of 2 weeks for the rejoinder. List thereafter for hearing.
Obliged, Lordship.
45.
May it please your lordship. Your lordship, I've just received the report. I'm praying for a week's time, your lordship, to file the affidavit.
Yes, MSN Inokandi GA submits that the report has since been received. He prays for around 1 week's time to bring the same on record.
Obliged, your lordship.
Affidavit.
Obliged, your lordship.
Interim, it's on until further order.
Interim order is on the order. It's already there.
46.
Maybe lordship. Matter pertain to the benefit of the clerical trade in Assam Rifle, my lord. Our matter has already been decided by the division bench also, my lord. This is a covered case, my lord.
Now we have to file affidavit. I'm praying for some.
Again and again, they are taking the time for affidavit.
What affidavit? What purpose is served, Dr. Mosika?
My lord, kindly see page number 154, annexure 8 of the report.
Just to see my whether it's squarely
Just
covered.
put on record.
Just to put on record, my lord, because there were 240 petitioners. My lord.
And against that order, my lord, we have already filed the contempt
Yes,
case
Mr.
also.
V. Kumar submits that the matters, this instant case is squarely covered by the judgments of this court, both in single bench, division bench. Now, however, Dr. Mosika prays he will have to put an affidavit on record. Yes.
3 weeks.
Yes. Notice of justice further times allowed. Yes. 3 weeks. Let him put on record is for their records.
My lord.
47.
Yes.
Okay.
Lordship, this is your lordship. Lordship, on behalf of the state, your lordship, we have the instruction you would need some more time, your lordship.
Your lordship, may I be allowed to file? Yes, your lordship. As per the instruction received, they have supplied the copy to Dusty Service, but I do not have any document to substantiate receipt. So may I be allowed to take first step, Your Honor?
What's the matter about?
Lordship, the matter here involved
VC?
Not VC.
Not VEC, Your Lordship. This is about the illegal demolition of a house which was granted under PMAYG scheme. and I was excommunicated.
How much? Where's 5, 6, and 7?
They have entered appearance on the last date, Your Lordship.
Take down. None appears for the respondents. Sorry, Mr. First. Sorry, with an issue under AAG, with so for respondents
1 to 4, Your Lordship.
I pray for the 2 weeks time.
2 weeks time, Your Lordship.
Filed affidavit. None appears on behalf of respondents 5, 6, and 7. With regard to respondent number 8, Mr. Esando appraised him allowed to take fresh steps.
By postal.
Same route within
1 week.
Taken within 2 days. Just after 2 weeks. For further order.
Highly obliged.
48.
May it please your Lordship. Lordship, we are here to receive instructions, my Lord. Can you grant me some time to file?
What's the matter about?
My Lord, this case is aggrieved by that order passed by the Deputy Commissioner, my Lord, for referring the matter for under Section 30, my Lord. Vulgar and Acquisition Act. Under Section 30. Whereby the application was rejected, my Lord.
Section 30 under the old act.
Yes, Your Lordship. The stressed petitioner names are missing in the notifications, Your Lordship.
Okay. Yes, Mr. Punjab, please for GA, please for allowed for a 2 weeks time to file affidavit. Yes, there's the after.
49.
We have taken steps, my lord, in this matter. This is only, my lord.
Where's MSR Kolni?
She has declined to take the notice, so we have taken steps.
But she appears all the time for MECL matters.
So we have taken steps, my lord. And it appears that it is served. If required, we will file an affidavit of service. Only to release my security amount, my lord.
Office note indicates that the AD cards not received on behalf 1, 2, and 3. However, Mr. SD, however, praised the email out to obtain status and to file affidavit necessary.
1 week, man.
Just after 1 week. Yes.
Hello, please.
50. 50.
Same, my lord, same order.
51.
51 of same order will carry me.
Hearing. 52.
52, my lord, as per the order of this honorable court, I filed my affidavit, bringing to record, my lord, that leave matter with the BSF personnel, my lord. So they were supposed to file an affidavit as per the order of this honorable court.
But I received instruction. 3 days time I'll file affidavit.
Oh, that BSF that
yes.
Leave for further studies, my lord.
So I filed my affidavit, my lord. And they were supposed to file within a week. There was an order of this honorable court. It appears, my lord, BSF always, my lord, defies the order of this honorable court.
3 days time I'll file it.
Yes, Dr. M. Mozika said
yesterday the instruction
that he has just received instructions. He prays for a lot of weeks time to file the additional affidavit.
They have just extended my. They said, my lord, if I clear, my lord, then they will allow me till 15th of September to file my application to join this.
Next date will dispose of.
My lord.
After 1 week or so.
53.
Same contempt.
Where were we last time?
My lord, I was pointing out only to my, because the record has become bulky, I had filed a summary affidavit again to only highlight the basic points that, my lord, I want to make. It's filed on 27/5/2025. Lordship has got it. Affidavit filed on 27/5/2025. At Annexure 1, page 9 is
1
the...
second. Filed on
27/5/25, my lord.
27/5.
5/25.
1/5/20.
Just bringing out the important papers, my lord, from the bulk.
Yes.
At Annexure 1, my lord, is the judgment, which, my lord,
Singh Chauhan.
Yes, my lord. Sorry, Madhavendra Singh.
What's the date? Just
My lord. No, my lord. After that, there is an additional affidavit filed. This was a summary submission. There's an affidavit, my lord.
Affidavit.
This was filed pursuant to an order dated 8/5/2025, where this honorable court asked us to bring out as to what is the discrepancy basically that is persisting.
Yes.
My lord, page 9 is the judgment in WBC 56 of 2013. The contempt, my lord, is basically against non-compliance of this particular judgment.
Yes.
Lordship knows the background, so I will not go into it. Fifth pay commission was directed to be implemented. But then this particular order was, my lord, passed. If your lordship comes to page 16 of this particular affidavit, this was passed pursuant to a previous round of litigation, which also went to the apex court, and after dismissal of the SLP, this implementation order had come at page 16. In respect of Savinder Singh Sohan, the line, my lord, I want to highlight in that order is the para 2, which says that Assam Rifles will publish VRO Part 2 order for redesignation / upgradation of the individual to the rank of Havaldar ORL. So precisely this order, my lord, is quoted, and we were directed to be given the same benefit. Though initially we said that, my lord, we also want a warrant officer ranked like the ciphers have got, because that is what the pay commission recommendation is. We are abandoning that part, my lord, that okay, if not warrant officer, give us Havaldar in this proper manner by saying that we are redesignated and upgraded to the post of Havaldar ORL. Then, my lord, would come at page 18. Page 18, my lord, initially they did the right thing, because this comes with the approval of the Ministry of Home Affairs. It says it comes from the approval with the MHA, and it says that we are upgradation, and I am direct to convey the approval of the competent authority for upgradation and redesignation to the post of Rifleman ORL to the petitioners only. So this in a way was, my lord, compliance. But then during this period, my lord, the writ appeal was also pending. Writ appeal got disposed, my lord, in next year, in March 2016.
Yes.
After disposal of the writ appeal, my lord, what they had done, Annexure 3, they reversed the order. And this is without approval of the MHA that we are pointing out, because the letter does not say, page 19.
They put in promotion.
They say that it is to be read as upgradation / promotion. So our entire...
Because the entire case is upgradation and redesignation.
And that is precisely the order of the court, because we were to be given the same benefit as was given, my lord, in WA 50 of 2010. The order is quoted. So this is precisely the order that ought to have been implemented in our case. So once you do it, and then you take it back again, while the contempt is still, my lord, alive. So therefore, my lord, there is a total non-compliance, my lord. And whether intentional or not, my lord, is a different thing, my lord. But then we can prima facie make out that there is non-compliance. So we are happy, my lord, if as of now, if this Annexure 2 order of 23 October 2015 is restored.
What about the subsequent, flood of litigation, my lord, with regard to, reaffirming this earlier order that was got in Justice Singh's order with regard to resignation? Then, but again, they had to come again, all trades by mistake. Maybe they extended to all trades because the other notification 98 did not extend to all trades. Fine, that is their mistake. They're paying for it. But then what in now? at this stage, in this contempt,
my lord,
what view can the court take with
my lord,
that is why subsequent litigation, with regard to now every case been passed again and again, that this is not a promotion, this is an upgradation, rationalize.
My lord,
what will be the purpose of this contempt now?
My lord, that is why
in the backdrop of all what has happened after this, after the numerous cases.
My lord, our order was categorical that you make it the redesignation and upgradation, because that is the order quoted in the judgment that we are, my lord, relying on. How can that be now modified and changed? Because this earlier order was also went to the apex court.
Mr. Pathak and all the other judgments.
My lord.
Yes.
And that is why I pointed out to Justice Pardiwala's judgment, saying that contempt not only goes to punishing, my lord, it has to be also ensured that the orders are properly complied. So to that extent, my lord, direction can be given, because the court never meant that.
But can we give direction in the contempt?
No, we are reaffirming what is already there. We are not saying something new, my lord.
Understood.
Because the order earlier very clearly says that this is the benefit you give.
But are there other who are co-situated with you have come and
filed writ petitions,
reaffirmation,
my lord,
in a sense,
my lord. They have, of course, the doctrine of election comes in, my lord. They can seek a different remedy. That does not prohibit our remedy, my lord. We are also right in a way saying that the order, which was specific in a regard, was initially sought to be complied and then it was withdrawn. So essentially it becomes a non-compliance of the order.
Okay.
So therefore, further direction now, if issued, is not actually a new direction. It is asking them to do what the court had earlier asked them to do.
That's not correct, my lord. The entire submission, is not correct, my lord.
Because otherwise every order of this court otherwise can be twisted by subsequently saying that we are understanding it in this manner, you come in a fresh round of litigation.
The only problem with this matter is that it's been lingering for how many years? That's the only thing. That is the real issue, the problem here. Not the orders that have been passed,
my lord,
or the order stated to have been violated, or that's the only thing. Yes. What do you have to say?
Well, what I'm saying, my lord, this has completed 10 years, my lord. It was filed in August 2015 and September 2025, my lord. Completed 10 years. Number two, in the original writ petition, my lord, there are 2,200 odd writ petitioners, my lord. This contempt is filed only by 12 of them, my lord. The present contempt. And about, in one writ petition, there are 97, my lord. In WPC 102 of 25, and another one there are about 50 or 60, my lord. They have come by fresh writ petition, my lord, because as a submitting, now what they want is a substantive adjudication, my lord, whether the upgradation given to them on 10/10/97, whether ACP can be set off against that or not, my lord. That is the only question. For that, from the same writ petition, about 200 petitioners have come individually by filing a writ petition before this Honorable Court. This Honorable Court has rendered a finding, my lord. The department is examining that. Writ appeal or maybe SLPs also, till the matter attains finality, my lord. So now by way of the present contempt, my lord, all those things cannot be, they are seeking to jump all those proceedings, my lord. They want to get a relief in the contempt petition, my lord, for which the others had to come by way of substantive writ petition. This Honorable Court has passed some order, my lord. Department is examining, filing an appeal against that. So if certain directions are given this in this contempt application, my lord, in my humble submission, those writ petitions or appeals, everything becomes infructuous.
Give a small note, we'll decide.
My lord?
Yes, we'll close it.
That notice already, in fact, earlier we had given a note, and my affidavit, as of now, this affidavit is basically a summary.
Give a small note.
This affidavit, my lord, that we have filed on 27/5, it is a summary, my lord.
But I'll submit a small note.
You submit the note, yes. Hearing is concluded.
Because essentially what they are doing is then, my lord, putting us back. Not only that, we have gone down. We have gone down to pay scale.
It's not that this court dealing with writ petition.
My lord, I understand.
We can pass expensive orders.
No, that is why
our jurisdiction is so limited. That is.
I understand. I understand. I understand.
I think on the last occasion we placed a judgment of the Honorable Supreme Court.
Justice Pardiwala judgment.
No, this is by Justice Kurian Joseph. 2017 5 SSC 506. It will be in the next matter.
Yes. Let's see the judgment.
Yes, I just give a copy.
Yes.
My lords, kindly have a look at paragraph 16 to 19, my lords. I'll just take your lordships.
16 to 19?
My lords. 16, my lords.
Restitutive measures. No.
My lords. Though Mr. Sham Devan, it starts from there, my lords.
Yeah.
Learned Senior Counsel has invited our attention to the judgment of this court and so and so, and contended that the courts must not travel beyond the four corners of the order which is alleged to have been flouted. In the background, which we have explained above, we find it difficult to appreciate the submission. This court in the judgment referred to in para 19 had clarified that the directions which are explicit in the judgment or are plainly self-evident can be taken into account for the purposes of consideration as to whether there has been any disobedience or willful violation of the same. Prima facie, we are of the view that the learned single judge had taken note of only of the plainly self-evident facts while issuing the rule and order regarding securing the amounts not relevant for our purposes. My lords, I'll just skip this and then
come to 23.
23 minutes. I'll take your lordship straight to 23. As held by the so-and-so and going to the court has a duty to issue appropriate directions for remedifying or rectifying the things done in violation of the orders. In this regard, the court may even take restitutive measures at any stage of the proceedings. This is already before the court. So it's not that the hands of the contempt court are tied. If it becomes evident, my lords, that the orders are not being complied with, then my lords have ample power.
You're not asking for a new direction.
The idea, if I may submit, my lords, is that it should not be that courts are helpless to, my lords, implement their orders.
You can't issue, fresh directions to reiterate what's already been.
My lords, but that's what. My lords, the Honorable Supreme Court says otherwise. My lords, that if a direction is plain and
the feeling of this court, doesn't it? Yes.
It cannot be, my lords, that a direction is passed against me and I interpret the direction in a certain way, which actually, my lords, ensures that the directions that flow from this Honorable Court are absolutely negated, and then come before this court and say that, oh no, I have complied. That cannot be the intention, my lords. And because if somebody is coming before this Honorable Court, my lords, we are also before a court of equity. And my lords are hearing the matter and then passing a judgment. It cannot be left open to the authorities, my lords, to interpret it either way. To that extent, my lords, the matter which was moved by my learned friend in the morning in the cipher category, my lords, whom I represent, your lordships are seeing, because there has been no end. People are still having to come repeatedly before this court. And now, my lords, that notification is there where the Ministry of Home Affairs has now referred this matter to DOPT and DOLA. I'll just place this before my lords.
My lord, till now I have not been able to understand the grievance of Mr. Paul's clients.
You already covered, Mr.
My lords, we are covered, but we have not got the relief.
But they should file an affidavit pointing out where the orders have not been complied with.
You're cipher, right?
My lord, oral I understand, my lord, but
cipher is before your lordships.
My lord, can I kindly see the last order also? Is Mr. Paul is supposed to file an affidavit indicating where there is non-compliance, my lord. At least I should know where is the non-compliance, my lord.
My lords, I had pointed out.
Filing a contempt application
my lords,
violation of this order.
I had pointed out.
Contempt is pending from since
2017.
Yes.
And my lords, the mere fact that, my lords, kindly look at the contents of this letter. This itself is self-evident. It's not one contempt.
Where we have violated what, my lord? No, my lord, they have not given anything. They'll hand over document like this, so I can't reply to this.
It's their own letter, my lords. It's not my letter.
My lords, I'm not carrying my entire office with
my lords, may kindly have a look at it. What does it say? MHA may please refer to the proposal contained in so-and-so regarding implementation of the Honorable High Court's order dated 1919 and regarding WPC number so-and-so, so-and-so. A contempt petition number so-and-so, so-and-so in the respective cases have been filed by the applicants on account of non-compliance of the above referred High Court orders. Next date is so-and-so. The matters has been examined. It has been observed that a similar court case of the Honorable High Court of Meghalaya was referred to MHA for seeking comments on implementation of the orders dated so-and-so 2014 in WPC number 61 of 13 filed by Yogendarappa Amrad. The matter was earlier examined by this matter by so-and-so, governing so-and-so, further in similar cases number so-and-so. In view of the above, MHA is advised to take appropriate decision in the instant matter in consultation with DOPT and DOLA. So there is no end to this.
Well, they should
Where
file,
is it pending?
They should file an affidavit indicating which part of the order has not been complied with. Well, at least we can answer that, my lord. Simply annexing a copy of the judgment, my lord, that this has not been complied with. They should say that this is the point which has not been complied. We will answer that. As far as overall, my lord, as I submitted, my lord, there is nothing. They have to file a fresh writ petition, my lord. Because of subsequent developments, the same petitioners have come and filed a writ petition, my lord. And as far as Mr. Paul's client, well, they should file an affidavit clearly.
Apart from the facts, only was the court's concerns about jurisdiction. That's only.
Well, I'll also place this one. Justice Pardiwala's judgment, my lords, have been pleased to see.
Judgments will not help you. Well, they have to first come to the facts that which fact where we have not complied with anything.
Well, even cipher, Mr. Paul discussed understanding that the cipher is over.
It's not, my lords, apparent. My lords may look at the date of this letter.
And here, my lord, the reference is to some different court orders, my lord, in different cases, not in their case, my lord. Yogendra Amrat is just altogether different case, my lord. They bring anything.
My lords, WPC 61 of 2030. That's what my friend is pointing out. That's from where we come in. The difficulty here, my lords, what if I may humbly submit is, my lords, that if there is an intention to comply, my lords, this kind of litigation does not percolate.
You see, if you go back to...
Well, this is WPC 403, from where my friend is getting 60.
Para 3.
You see,
no, I am 403. 403, emanates from 61.
Refer seeking comments and finish order so-and-so, file 61 filed by so-and-so.
Well, kindly see, my lord.
Examined.
Well, kindly see it.
Because, well, our writ petition also flows from Yogendrappa's case. I had the occasion to appear in that matter, so I'm aware. It all flows from there.
Well, the present writ petition is WPC 403 of 2014, my lord, again, for which the contempt has been filed. A reference to some other case, my lord.
In this case, in this communication.
This communication with regard to different case, my lord.
But then they're similarly situated, Dr. Mozika, that's the only thing. Because if the letter reflects as such, because further in similar cases, so and so,
it has been examined,
implemented in consultation with DOPT. So in view of the above, it's advised to take appropriate decision in some matter. That means they are advised to follow the earlier decisions taken by the Ministry of Home Affairs. That's all. That's the only thing.
So, my lord, these are the cases to file a fresh writ petition, my lord. They will not be foreclosed on from, but they should file a fresh writ petition.
And my lords, then we'll again go back to the ministry first, then to DOPT, then to DLA, and then, my lords, maybe 10 years hence.
This side also, my lord. So,
no, I can understand.
Sufficient at that point of time, my lord.
I can.
The thing is like this. What can be done is, notwithstanding the contempt and jurisdiction, like in view of, this memorandum that have been passed, so they can examine accordingly whether there's been willful. We cannot hold as willful or violated because there's been too much water under the bridge. That's the only thing. But in the interpretation, whether now to discern whether compliance or non-compliance or manner of compliance, one constitute contempt. That's a different.
My lords,
that is a different.
My lords, may I make a suggestion, subject to what my lords feel it is appropriate? Since, my lords, the stand of the Union of India is that they have actually complied with the directions passed by those honorable court, my lords, in toto. Let it come from them, my lords, that this is the manner in which this order was passed, this is what is the purport of the order, and this is how we implemented it. Things will be very clear.
Reverse burden cannot be put on us, my lord.
My lords, if there's no reverse burden, the burden is on the Union of India to comply. My job, my lords, in contempt jurisdiction, it is between the court and the respondents. My job is only to bring it. So if I am bringing it to your lordship's notice, and my lords, this contempt has survived for 10 years, it is but natural that the person who says I've complied comes before my lords, in so many words, files an affidavit by somebody, my lords, who's responsible, and says, this is the order, this is how we have interpreted it, and this is how we've complied with it. Matter ends. If after that, if my lords feel that there's nothing survives in this matter, your lordships will close the matter. Because I'll keep on bringing documents, my lords, I'll keep on bringing, matter will never end.
Kindly say the last order, my lord. What is the last order?
It'll never end.
In this matter only. Can you see the last order?
Earlier, my lord, I had also placed a judgment in Gauri Sankar Prasad's Rai's case. There also, my lord, the issue of regularization was there of certain workers. My lord, the Apex Court in that case also found that there was no total compliance. So instead of issuing a fresh direction, my lord, it says that we are giving you one more opportunity to comply with the judgments in total.
It is the finality that is there with the.
Why I came up with that suggestion?
But can't you see the last order?
My friend is saying that I filed those documents. I'll bring it on record. 31-7 order, Malaj. I'll bring it on record. They'll again say, Malaj, this. There's no end to it. If I am, Malaj, for once, for the sake of arguments, Malaj, not conceding, I say that okay, very well, you have complied with it. You have to tell the court how you have complied with it. Matter will end over there.
Okay.
If my lord,
since the order of the court is there,
my lord,
there has to be, you know, whatever it is. You file something,
my lord,
we will close it the next day. Positively, I'm not going to make this matter.
My lord, that is with regard to the second item, my lord. The first item is different, my lord.
First item is
first item. I'll place my note.
Just place your note.
I'll place my note.
My only, my lord, the submission would be that my affidavit, my lord, points out that the earlier judgment said that you do this. Instead of doing A, they have done B, my lord. So if that is compliance, my lord, what can they tell us now that you come in the second round of litigation?
Your own petitions have come.
Case, my lord,
54.
They can be asked again to comply.
After 2 weeks' time is granted to the petitioner to place on record the part of non-compliant, the part of the order has been not complied. So Mr. Paul's also produced a communication dated
24th July 25, man.
23rd July or 24th?
Well, the covering letter is 24th.
24th July, so and so. The net DHC had to obtain instructions on the same before the next date. Yes. Your matter we're closing.
We have to file a petition.
Why you put
no, my learned friend is presupposing, Malaj, I suppose.
No, moment it is closed, our doors are also closed, my lord.
No, they could have done that in 5 years.
We have to come through another door.
I'm repeating same thing that please file a withdrawal.
No, the problem is that
this
shows that the union knows that we have not complied. Therefore, they say that there is a cause of action. You come again.
It's contempt to
I'm not asking for a fresh direction, Lordship would only consider that.
I'm only asking. If I may,
it's about knows what's troubling the court that the fresh directions can be issued or not.
That's the only issue that
on paper, Bharat, your case granted. But the events that are surrounding it, that's the only problem. Whether we can issue fresh directions or not.
Then the question would come.
They will run straight to Supreme Court and say like, we are in contempt.
No, my lords. But my lords would kindly appreciate whether my lords delay or my lords pendency of this matter before this court would my lords enable them to go scot-free in this matter.
Yes.
That, in my humble submission, may not be the position. If I have not complied, I have not complied. Every day is a new cause of action.
But we have been there since 2016. And when the writ appeal was closed, might not see that record. This issue was to be taken up separately. There is an observation in the writ appeal as far as the compliance or non-compliance is concerned. Because we raised that grievance in 2016.
We will I will not pass the order right now, then file the note, then when, after 2 weeks, when the other matter comes, then we will, together we will.
I'll oblige.
Don't reserve it, we fix it together 2 weeks just only for filing of notes. Yes.
In the meantime, I'll file my affidavit. I'll oblige.
Deep.
Seven.
May I please, Your Lordship? My Lord, I'm an associate professor in Nehu under the Life Science School, my Lord.
1 second. This is?
My Lord, before my learned friend starts, Lordship will see the last order because this matter came up for admission. Substantially matter was heard long time back, my Lord. Lordship has passed an order because we question the maintainability of this case. So on maintainability matter, and the Lordship has said that this issue remain open.
Then you start. No, we will have a final hearing on the first hearing.
Yes, my lord. If they overcome the maintainability, my lord.
There is judgment, recent judgment, which has been passed by the Honorable Supreme Court, and my learned senior may correct me if I'm wrong. It says, my lord, we find that the process of conducting separate interview of the post of assistant professor under general category and obesity category is wholly illegal. In this matter also, my lord, they have done it two different categories, OBC and general, my lord, which is already illegal, my lord, has been declared by the Honorable Supreme Court. And the Honorable Supreme Court has also said, my lord, when the statutes and the rules are not followed, my lord, even a person who has been a part of the selection process, my lord, can challenge, my lord. So the question of maintainability, my lord.
I think I can make my submission after that. He can answer. He can answer it. Always.
I'm appointee of OBC category.
My learned friend.
For striking off the name of previous number 6.
Let us start with maintainability. Let us start with the maintainability, your lordships. My lord, he can always.
Make up your mind. This court's open to maintainability, not maintainability.
No, because maintainability. Why I am on the maintainability, my lord? Catena of decision, including the decision of this, I mean, Guwahati High Court, my lord, pertaining to Shillong, my lord, Nehu only, which categorically say a person, a candidate who is not participating for a particular post, my lord, he cannot, my lord, question.
Just give me 5 minutes.
Yes.
Come back. Wait for the thing. 5 minutes. I've been having this, this bad thing doesn't seem to go away. And that's why.
You to start?
May it please your lordship.
You question on the first view on the maintainability aspect.
Yeah, maintainability. I'll go on to maintainability. For that, I'll have to little bit, my lord, what kind of post, how many post advertise, that I'll have to place.
It's going to the merit of the case.
No, not at all, sir.
There'll be a background, doesn't matter.
Just the background, that I'll have to explain, my lord. My lord, 3 posts for the Professor Geology were advertised, my lord. Out of these 3 posts, my lord, 1 post was reserved, 1 was open, 1 post was reserved for OBC, 1 for EWS.
1 is UR.
OBC. 1 is unreserved, my lord.
Yeah, 1 is OBC.
1 is for OBC and 1 is for EWS, Economically Weaker Section. My lord. Now, my lord, this advertisement, 3 posts were called, my lord. Out of these 3, my lord, appointment was made in general category. 1 post, 1 appointment was made. Now he has been implemented as respondent number 7. And against OBC, my lord, respondent number 6 was selected and appointed. Now, my lord, mode of applying, my lord, now it is different, not like online everything. It's a mandatory. The mode of, my lord, applying for the post, the application has to be filed online, my lord, after going to the necessary portal, followed by submission of hard copy. Now, my lord, so far respondent number 6 is concerned, your lordship, who has been appointed against, my lord, the OBC post.
Yes.
He also applied for OBC, separate application. I'll just come to that. Well, he filed a separate application for OBC and he also applied for general. 2 separate applications, my lord, online.
Okay.
Filed, your lordship. Followed by submission of hard copies. Now, my lord, so far the writ petitioner is concerned, my lord, admitted position on the record I am saying, my lord, he applied for the general post, open post.
Yes.
Now, my lord, what happened? Now, your lordship, just want to apprise your lordships. So far the selection of teachers in the central university is concerned, my lord, this is regulated by the regulation issued by the UGC from time to time. Normally, my lord, what it happened, it coincide with every, my lord, pay commission, my lord, central pay commission reports. So, my lord, after, my lord, completion of the, my lord, pay revision and as accepted by the central government, then UGC, my lord, takes up the matter with the Ministry of Education. They comes up with the, my lord, revised pay scale of teacher, because central government, my lord, central pay revision never provides for the pay scale of teacher, as well as other condition of service, like, my lord, the qualification, mode of selection, constitution of selection committee. Now here, my lord, this was held sometime in 2022, your lordship. Now 2022, my lord, the UGC regulation which was holding the field was, my lord, where is that UGC? Holding the field, my lord, was UGC regulations on minimum qualification for appointment of teachers, other academic staff in university and colleges, and measures for maintenance of standards in higher education 2018. Well, for the sake of brevity, I'll call it regulation of 2018.
18 or 22?
18.
They were holding the field.
Still holding the field.
Now also.
Now it will be, my lord, likely to be replaced, my lord, when the 8th pay commission comes. These will come sometime in 28, effective from 26. Then a regular. As of now, this is holding the field. Now, as per this, my lord, regulation for, my lord, they have laid down, my lord, what are the, my lord, how the selection committee constituted, who are the members of the selection committee. Now they have provided, my lord, altogether a different selection committee for considering the case of reserve category. They have provided, my lord, if it is a reserve category candidate, then in the selection committee, there has to be a member, my lord, who comes from that background. I think lordship has dealt with that case also, once came up, filed by my learned friend only. Has to be, my lord, from the reserve category. So, my lord, here what I am trying to say, your lordship, the writ petitioner,
He applied for a post, my lord, and his case was considered by a selection committee, my lord, and the case of the respondent number 6, my lord, was considered by a different selection committee. His case was not there before that selection committee.
Okay.
Now, my lord, the admitted position is this.
Yes.
He is not a contender for the post of OBC.
Yes.
He is not a contender for the post of OBC. He never applied for the post of OBC. That selection is different.
Yes.
Committee is different. Respondent number 6 was found suitable. He was appointed. Now, my lord, here I will just place before my lord the law. Now, what the law say? Number 1, my lord, I think our High Court decision also I will place, my lord. One thing they say, only a person aggrieved whose right has been infringed, he can challenge an appointment.
Yes.
Now, my lord, my question, my lord, even tomorrow if your lordship, assuming, my lord, the lordship set aside the appointment of respondent number 6 who was appointed against OBC.
Doesn't mean he'll be appointed.
He will not, because none of his right has been infringed, my lord. So the Supreme Court as well as our High Court, my lord, relying on Supreme Court decisions, if you are not aggrieved, you are not participating for that post, you cannot challenge it. You are barred from challenging it. Now, my lord, here I will rely on some decisions. I will start with my lord GLT 2. I start with my lord Guwahati High Court's, my lord, decision. That is also relating to Nehu. I have given. Page 87, para 3 and 4.
Right, first.
3.
Which one?
GLT,
my lord.
Which year? Just give citation.
2007, 2 GLT, page 87. Relevant paragraphs are, my lord, para 3 and 4.
Zever Meow.
Yes,
my famous Zever Meow.
This is, my lord, 2007, 2 GLT 87.
Yeah.
Relevant paragraphs are paragraph 3 and 4. I'll just read it.
Yes.
The question of locus standi again came up for consideration before the Apex Court in Ghulam Qadri, a case cited by the Learned Counsel for the respondent university. While duly noting the recent far-reaching changes in the orthodox rule of interpretation regarding locus standi, the Apex Court observed at paragraph 38 of the judgment as follows. There is no dispute regarding the legal proposition that right under Article 226 can be enforced only by an aggrieved person, except in the case where the writ prayed for is a habeas corpus or quo warranto. Now, my lord, my question, my lord, how he is aggrieved for an appointment made in a reserve post? He is not a contender for that post. Another exception in the general rule is the filing of a writ petition in public interest. The existence of legal right of petitioner which is alleged to have been violated is foundation of invoking jurisdiction of the High Court under Article 226. The orthodox rule of interpretation regarding locus standi of a person to reach the court has undergone sea change with the development of constitutional law in India, and constitutional court have been adopting liberal approach in dealing with the cases or dislodging the claim of litigant merely on hyper-technical grounds. If a person approaching the court can justify that the impugned action is likely to adversely affect his right, which is shown to having secure in some statutory provision, the petition filed by such person cannot be rejected on the ground of his not having locus standi. In other words, if the person is found not merely a stranger having no right whatsoever to any post or property, he cannot be non-suited on the ground of his not having locus standi. The second part is also categorical. At least you will have to show the sum of your right has been violated. You are not a contender for that post, my lord. Even if your lordship set aside, my lord, his case will not be considered. He has never applied for that post. Now the paragraph 4. Thus the question whether a person has locus standi to bring a proceeding under Article 226 of the Constitution depend mostly on whether he possesses a legal or fundamental right and whether such right has been violated. The well-known recognized exception are a writ of habeas corpus, writ of quorum, and a public interest litigation. No other exception appears to have been developed as yet by the Apex Court. The enormity of the infringement of the laws by the authorities is hardly relevant for determining the right of the citizen to invoke Article 220 unless he is personally aggrieved by the action or inaction of the authorities. The proposition of law on strength of his case, not on the weakness of the case of the opponent. So here he is basically, my lord, without participating, my lord, without applying, he is basically complaining. In my opinion, this fully takes care of the submission of the learned counsel for the petitioner that for determining the standing of the petitioner, this court should examine the merits. Okay. I have carefully gone through the decision of K. Shekhar, upon which heavy reliance was placed by the learned counsel. I. Shekhar, one of the proposition was called for consideration before the Apex Court was whether respondent number Y did not have locus standi to challenge appointment of appellant either as a lecturer in 1986 and subsequently as assistant professor in 1990 in the National Institute of Mental Health, not only because she herself had not applied pursuant to the advertisement dated, but also that she did not have necessary qualification to be appointed to either post. The contention of the respondent number 1, on the other hand, the Imams had appointed the appellant as assistant professor by backdoor method, contrary to the recruitment rules of such and such, without completing the process started by the third advertisement, and that her claim was overlooked, although she was fully qualified only to accommodate the appellant. The findings of the Apex Court on this controversy are found at paragraph 28 of the judgment. It may be stated that the respondent 1 could not directly challenge the appellant's appointment as lecturer in centers either because she herself was merely not an applicant but was unqualified to be appointed or on the ground of delay. But the immediate grievance of the respondent number 1 was the appellant's appointment in 1990 as assistant professor. Because the appointment was the result of appellant's appointment as a lecturer in ICM Center 1986, it was called into questions. To get rid of the which to speak, one had to eliminate the root. It is nobody's case that the respondent number 1 could not be considered for appointment as assistant professor in 1990. The writ petition filed the same year. There was such no question of respondent number application being defeated because of any delay. That is, my lord, the initial appointment, my lord, was through backdoor. So this is what the law is. So what has been categorically laid down here, you will have to show that your right has been infringed. When you are not a contender for this post, my lord, where is the question of that question will come? So, my lord, all these cases, my lord, basically they relied on the Supreme Court's judgment. Same paragraph, that Kadri's judgment. This has been, my lord, I will not repeat it. I have that judgment also, my lord. That is paragraph 38 of a decision, my lord, 2002 1 SSC. Page 33. Ghulam Qadri versus Special Tribunal and others. Para 38, my lord. The same paragraph, my lord, which has been quoted in this judgment. Which has been quoted in this judgment. And this case, my lord, here also this case, because I myself appeared, my lord, on behalf of Nehu in this case, Xavier Mao. He was not a contender for it, and he came and challenged. And that was dismissed.
Yes.
So, my lord, other judgment, my lord, already, my lord, this is a judgment they have referred to this Supreme Court judgment. Then your lordship, my lord, on public interest litigation. There was a public interest litigation in service matter was filed before the division bench of this honorable court, my lord. That is also reported in 2007, SSC Online, Guwahati 436. There also, my lord, the division bench of Guwahati High Court, my lord, held held that, my lord.
1 second.
Held that, my lord. The public interest, my lord, public interest will not lie in service matter. Only a person aggrieved whose right has been infringed, who has been affected.
That's being examined again by the Supreme Court now.
Lordship. But situation has
As it
not,
stands now, yes.
my lord, situation has not changed. But of course, if they come out with
that's being examined again, whether public interest can be entertained in service matters. Anyway, that's just one discussion.
So, my lord, ultimately, my lord, whether it is a service, public interest litigation or others, my lord, the contention, my lord, that you will have to show that your right has been infringed, fundamental or otherwise. If you cannot show that, my lord, you just cannot challenge, my lord, an appointment.
Which paragraph?
My lord, that is paragraph, my lord, 3, my lord, paragraph 7.
Yes.
K.D. Ramsaj. Shall I read it, my lord?
Yes.
When the court pointed query as to the availability of the decision of the apex court on the maintainability of the period of service matter, no such authority is submitted by the petitioner. On the contrary, the State London Council, appearing for Nehu, cited the decision of Durjanan Shahu, Jindal Kumar 1987-2003. In fact, my lord, in that judgment, lordship, that was a little harsh. The Supreme Court has made an observation. In spite of our repeated saying that public interest is not maintainable, it has been noticed that many of the high courts are flooded with public interest litigation in service matters. So, my lord, basically is saying this, relying in this judgment, my lord, that public interest litigation was dismissed. The contention was same. My lord, your right has not been infringed. Only a person whose right has been infringed, he can maintain a writ petition, assailing a appointment. What is the 2021 SSC? Then, my lord, recent judgment, my lord, similar line, my lord, 2021 SSC online. There is a Kerala, of course. Kerala High Court, they relied on, my lord, Guwahati High Court's, my lord, judgment, Nehu judgment.
Xavier Mao.
My lord. Xavier Mao, and they have relied. That's why only for that I am relying.
Yes.
That is para 44. Paragraph 44. The Guwahati High Court held as under. Thus, the question whether a person has the locus standi bringing a proceeding under Constitution depends mostly whether he possesses a legal or fundamental right. The same thing has been quoted there. So this is, my lord, I am relying only because Kerala also relied on that judgment in 2021.
Yes.
So, my lord, what I want to convey, my lord, by relying on this judgment, the situation has not changed, my lord. So far, the proposition of law that a person only aggrieved whose right has been infringed, only he can maintain a writ petition assailing an appointment. So my humble submission, my lord, here the writ petitioner is assailing, my lord, the appointment of respondent number 6. Admittedly, my lord, he was appointed.
Only one aspect. You're saying respondent number 6 applied both for unreserved and for OBC.
My lord, I'm coming.
Is that permissible?
No, it is like this now. It has to be. Because now all these things are, my lord, I can place the records. I have looked into the records.
But doesn't it stand to reason that, you know, in all selection processes, okay, might have, okay, unreserved, then reserved category, then you have SC, ST, whatever, OBC, correct? Now, suppose cutoff for ST is 60, right? Oh, so I forget about cutoff. Now, a reserve candidate, he scores, you know, more than any other candidate. Then he straight away slotted in the unreserved because the open. Unreserved means open. Doesn't mean that unreserved means only for, you know, those open candidates.
No.
So once he slots top marks, then he comes in number 1. He takes a seat of the unreserved category. Correct.
Well answered.
There's no question of having separate selection for OBC and for open category. Is one selection process.
Okay.
Maybe other submission is that if it considers that must be under special circumstances, we'll look at the regulation. Whether now when it comes to selecting an unreserved candidate, you're adopting different, you know, standards by putting a unreserved, like interviewer in the board.
Yes.
Now, on the, what's the rationale behind that?
Yes. No, my lord, this is the reason, my lord. The selection of teachers.
So why selection of teachers? Not only that, why is there two selection processes for the same post? Because post will be the same. Suppose they are applying for, suppose the example we have judicial magistrates, right? Now we have unreserved posts also. We have reserved posts, right? As per the 40-40 whatever. Now, usually you see now, is a tribal candidate also takes first position, right?
Yes. Then he goes out of, my lord, the reserve. Then he is.
He goes to reserve. Then he comes. Yes. Even in the matter allocation of seats, also you see medical seats now. You'll find me 1, 2 unreserved. I mean open like non-tribal candidates who are. Then the rest, even in open category, you find tribal candidates who have obtained a seat out there. Now that's the only thing which is troubling the court. As to whether you have to clarify why has Nehu adopted, even if the British stands nothing to gain, but
no, yes. The reason, my lord, why? Because application has to be filed online. No, that doesn't matter.
Why you file two applications?
No, it doesn't matter. The reason is, my lord, UGC regulations.
You have to file two applications.
UGC regulation, no, my lord. UGC regulation. No. What I am saying, my lord, it follows, my lord. Consequentially, it follows. Why it follows? Because there are separate selection committee. Lordship will take note. There are separate selection.
Same post.
Same post. If it is a OBC, my lord, selection committee is different. If it is general selection committee is different. So in his case,
where is that prescription?
Yes,
that's the only thing that we want to be clarified.
Yes, my lord. That initiative came to my mind. This is the reason I sought the instruction. It is there. Because when it comes to OBC, the strict requirement under UGC regulation, that selection committee will have to have a member who comes from the same background. So here the complexion changes. And once the complexion changes, a fresh assessment is called for. That's, my lord, makes the difference. Otherwise, I understand, my lord, UPSC, MPSC, everywhere a single application. If you are scoring very high, you are out of reserve, you will be considered for this. But the university, it cannot be. I'll just, my lord, I think I have given the list. That is UGC regulation. Where is that paragraph?
This is Standard Education Institutions Reservation Teachers Cadre Act 2019.
No, not that.
I'm
referring to this, my lord, UGC regulation on minimum qualification for appointment of lordship.
You've given earlier on, no?
You have not given that.
No, she gave a different one.
Lordship is not having a copy.
I don't think it's supplied. No.
My lord, lordship is not having. My lord, this is it is there. My lord.
No,
that is 5.1. Selection committee compositions.
1 second. For assistant professor.
My lord, lordship will come to the next page. My lord, 3, Roman 3, professor in the university.
Page
71.
Yes.
Well,
Professor.
6. Yes, Lordship, Professor. No, my Lord, Lordship will come to, my Lord, clause 6.
Next page.
Yeah, my Lord, 71.
71 is...
No, my Lord, Roman 6. Under 3, clause Roman 6. Lordship has got it.
Yes.
An academician belonging to SC, ST, OBC, minority, women, differently able categories, if any of the candidates representing these categories is the applicant to be nominated by the Vice Chancellor, if any of the above members of the selection committee does not belong to that category. So, my Lord, in case of a reserve category, my Lord, there has to be an academician from that background. So, here the complexion changes and a fresh assessment is done. There cannot be a common assessment, my Lord. What is in the Lordship's mind, single application and a common assessment. It cannot be here. So, my Lord, an assessment was done separately. In fact, I have looked into the record, my Lord. My Lord, so far 6 is concerned, in the assessment in general category, my Lord, he fall well short. Well short, my Lord, in the general category. Now, when it comes to the reserve category, my Lord, he was found the most suitable. So, my Lord, his case, my Lord, he neither applied, my Lord, and he is not concerned with this selection. His case was never before this selection committee, my Lord. So obviously, my Lord, he has never applied for that post. So, my humble submission, my Lord, going by the proposition and ratio which are categorical and clear, my Lord, and I have looked into this ratio has not changed, Your Lordship. Unless you are aggrieved, your right has been infringed, statutory or fundamental, you cannot maintain a writ petition assailing an appointment. So, my Lord, on this count, it goes, my Lord. Either they withdraw the writ petition, my Lord, and come up afresh, though they have challenged the general category appointment of general category candidate and respondent number 7.
Who's paying number 7? But who's more I mean, in the selection, you are better.
Yes, no, I'm number 1.
Yes.
And here, my Lord, the composition of selection committee is not under challenge. If he had challenged the composition of selection committee, those things are not a challenge. He is straightway hitting on the merit. That this person was less meritorious, I am more meritorious. Now, how you say in a reserve category that?
Why, Mr. Changreso, you want to be struck off?
Only for this.
I'm not a necessary party.
Why?
I belong to I belong to OBC category.
On that ground, no?
Yes, I supplement my Lord.
Yes.
Not my very serious
yes.
argument and supplement a few.
Yes, what do you have to say?
Yes, please.
Well, my right to be appointed in the reserve category is very clear, derived from my Lord Article 14, Article 16.4. Now I have applied for 2, that the selection process clarified by Learned standing out for Senator Nehru. Now, even if I don't apply for UR candidate, unreserved candidates, my right to be considered for general post remain there, provided I outshine the candidature of the performance of the general candidates. Now here in this case, I applied for both. Now I have 2 applications. 2 applications are there, because of the regulations of the UGC norms, like Learned has highlighted. My candidature was examined by the selection committee for the OBC category, and I was found suitable and appointed. Now, therefore, none of the rights of the petitioner has been violated, my Lord. Now, challenging my appointment is, in fact, my Lord, he is entering to a prohibited territory. It goes against the very fabric of the constitutional provision, my Lord, because he is not a general candidate, he is not the OBC candidates. Regarding this point, my Lord, once Supreme Court decision is there, here in this case also, my Lord, one of the person who doesn't belong to ST candidate challenged the validity of the certificate of the ST who got the employment. But the Supreme Court held, that is 2013 for ACC, my Lord. Page number 465.
Yes. Paragraph?
Paragraph, my Lord. May I start from paragraph 10, my Lord. Few paragraphs. And here Apex Court impose a heavy cost upon those respondent who doesn't belong to that ST category. But may I start from paragraph 10.
Yeah.
A legal right means an entitlement arising out of legal rules. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychological or imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. In such and such case, a similar view was taken by this court, observing that if a person claiming relief is not eligible as per requirement, then he cannot be said to be a person aggrieved regarding the election or the selection of the other persons. In such and such case, my lord, the expression aggrieved person denotes an elastic and elusive concept. It cannot be confined within the bounds of a rigid, exact and comprehensive definition. Its scope and meaning depends on diverse variable factors such as the content and intent of the statute which the contravention is alleged, the specific circumstances of the case, the nature and extent of the complainant's interest, and the nature and extent of prejudice or injury suffered by the complainant. This court, even as regards the filing of a habeas corpus petition, has explained that expression next friend means a person who is not a total stranger. Such a petition cannot be filed by one who is a complete stranger to the person who is in alleged illegal custody. My lord, may I come down to 15. As regards the filing of public interest litigation, this court has consistently held that such a course of action is not permissible so far as the service matters are concerned. My lord, number 17, my lord. In view of the above, law on the said point can be summarized to the effect that a person who raises a grievance must show how he has suffered legal injury. Generally, a stranger having no right whatsoever to any post or property cannot be permitted to intervene in the affairs of a person. As regard respondent number 5 does not belong to the scheduled tribes category, a garb adopted by him of serving the cause of scheduled tribes candidates who may have been deprived of their legitimate right to be considered for the post must be considered by this court in order to determine whether respondent number 5 is in fact in a legitimate position to lay any claim before any forum whatsoever. May I not come to 23, the next page, Your Lordship?
Yes.
Well, the next thing. Thus, from the above, it is evident that under ordinary circumstances, a third person having no concern with the case at hand cannot claim to have any locus standi to raise any grievance whatsoever. However, in exceptional circumstances as referred to above, if the actual persons aggrieved because of ignorance, illiteracy, inarticulation or poverty are unable to approach the court, and a person who has no personal agenda or object in relation to which he can grind his own acts approaches the court, then the court may examine the issue in exceptional circumstances, even if his bona fides are doubted, but the said issue raised by him in the opinion of the court requires consideration. The court may proceed so modo if such respect, in such respect. But the last para, my lord, 47, my lord. Para 47 and 48, running page, my lord, 489. The appeal is disposed of according, however, considering the fact that respondent number 5 does not pursuing the matter in a bona fide manner and has not raised any public interest. Rather, he abused the process of court only to harass the appellant. Respondent number 5 is restrained from intervening in the matter any further. He also from remaining a party to it, and he is also liable to pay a cost to the tune of rupees 1 lakh within a period of such and such, my lord. My humble submission is that, my lord, he is not espousing any public interest. He is espousing his own cause. He has to first ensure that he belongs to the OPC category. Then he can agitate any grievances before, my lord. Admittedly, my lord, he doesn't belong to. Therefore, in fact, I'm wrongly impleaded. But he has only rights to agitate, my lord, provided if appointed in the reserved category, unreserved category. In that event, my lord, I've cited earlier occasion also. I will not take a long time. My lord, 2006 volume 8. But I've given the list of book. 2006 volume 8 SSC, page number 121. 2212, man. Para 60. In Nagaraj case. Para 60, man. 60. 60, man.
M. Nagaraj.
The reason I cited, my lord, the way the writ petition pursuing the matter as if I appointed in the reserved category, unreserved category. Just 60. In interest Sauni, Jivan Lady Justice noted that reservation under Article 16.4 does not operate on communal ground. Therefore, if a member from reserved category gets selected in a general category, his selection will not be counted against the quota limit provided to his class. Similarly, in Arkansas, the Supreme Court held that while general category candidates are not entitled to fill the reserve posts, reserved category candidates are entitled to compete for the general category posts. The fact that considerable number of members of the backward classes have been appointed, promoted against general seats in the state services may be a relevant factor for the state government to review the question of continuous reservation for the state class. But I'm trying to bring home, my lord, that my right to be considered for general poor, it is remain under Article 4.
Intact,
yes, intact. Therefore, my lord,
that is not in
therefore, by merely filing application for general post, that doesn't take away my rights, and that doesn't affect his rights. His right under Article 14.1 remain the same. So also me, and my appointment admittedly admitted by him is that, my lord, I belong to reserved category. Only my two paragraphs I read out the reason why he implemented me. He has reflected it in his rejoinder. First, my lord, para 4 of my affidavit, I sought for, my lord, striking out my name. Or otherwise, the writ is not maintainable. Para 4 of my affidavit.
Yes.
Para 4, my lord, I specifically pleaded for striking off my name, and the writ is not maintainable. In response to this, my lord, he has filed the rejoinder. The only reason he has taken for implementing me as a party here is available in para 4 of his rejoinder. Dated, my lord, 2nd April 2024, he filed. Para 4, my lord. Paragraph 4.
Yes.
My lord, the averment made in paragraph 4 of the affidavit in the possession are vehemently denied by the petitioner. On the contrary, it is stated that the instated petition is a fit case, warranting interference by this honourable court under Article 226 of the Constitution of India. Inasmuch as the instated petition has been filed asserting the impugned letter sunset, appointed respondents 6 and 7 to the post of professors in the Department of Zoology, NEHO, in pursuance to executive government sunset, even though they failed to fulfill the eligible criteria as laid down by the UGC regulation and the specializations mentioned in the advertisement. It is important. It is further stated that the respondent number 6 had participated and screened by the selection committee under both reserved and unreserved category. This is the only reason. So how it affects his right? It doesn't affect his right at all. Therefore, my right to face the candidature as a reserve category flows from Article 16.4. My appointment is definitely under Article 16.4. Therefore, none of his rights is violated. So, in fact, writ petition is not maintainable.
Yes. Yes, Mr. D.
My lord.
You can finish before lunch, 1:15?
I will, yes, I'll take a bit of time because maintainability cannot be decided without going into the merit of the case, my lord. The merit has to be touched.
You are free to traverse anywhere, but
yes,
we'll decide the question of maintainability first.
Yes.
First, Mr. Nombri, you have anything to say?
Yes, my lord. I am on Estopel, my lord. Doctrine of Estopel.
Why Estopel?
My lord, the petitioner having taken part in the selection, my lord, now cannot come because he filed a writ petition on the first round, my lord, that was dismissed on the same grounds, my lord. So, my lord, now after being, my lord, unsuccessful, he is before your lordships, my lord. I'll just cite only one judgment, my lord. This relates to appointment of professors. Now, this is a judgment reported in 2016 volume 1 SSC page 454, my lord. This is in the case of Madras Institute of Development Studies and another. Your Lordships will find the facts at para 2 to 4, my lord. I'll just read, my lord, para 2 to 4. The facts of number 2, the facts of the case lie in the narrow compass. The Pellin Institute issued an advertisement calling for the application for the position of professor, associate professor, and assistant professor. The said advertisement contained a description of the 3 qualifications required to be proposed by the candidates. Several persons, including respondent number 1, writ petitioner, submitted application for appointment to the post of associate professor. The shortlisting of the candidates was done by the director of the institute in consultation with the chairman after informal consultation with senior professors for evolving the criteria for shortlisting the candidates. The selection committee, consisting of 3 noted social scientists as contemplated under the rules, conducted interviews and recommended a panel of 5 names. Thereafter, the executive council, by order dated so-and-so, approved the appointment of various persons to the post of professor, associate professor and assistant professor. Since the institute had advertised for the 3 posts, the first 3, that is respondent number 2, 3 and 4, initially approached for the post of associate professor. Number 3, respondent number 1, writ petitioner challenged the aforesaid decision dated so-and-so on the ground that inter alia the selection was not done strictly as per the qualifications mentioned in the advertisement, and respondent number 1, writ petitioner having fulfilled all the requirements ought to have been selected to one of the 3 vacancies in associate professor. It was also alleged by respondent number 1, writ petitioner, that there has been infraction in the recruitment rules. Number 4, the Pellin Institute denied and disputed the allegations regarding infraction of recruitment rules and further denied and disputed the allegation of irregularities in selection process. Now, my lord, the findings of the court, my lord, of the Supreme Court. Your Lordships may kindly have para 14. So this is where estoppel comes, my lord.
Yes.
Para 14.
Yeah.
The question as to whether a person who consciously takes part in the process of selection can turn around and question the method of selection is no longer res integra. Para 15. In G. Sarana University of Lucknow, a similar question came up for consideration before a 3-judge bench of this court, where the fact was that the petitioner had applied for the post of professor in anthropology in the University of Lucknow. After having appeared before the selection committee, but on his failure to get appointed, the petitioner rushed to the High Court pleading bias against him of the 3 experts in the selection committee consisting of 5 members. He also alleged doubt in the constitution of the committee, rejecting the contention the court held as under. We do not, however, consider it necessary in the present case to go into the question of the reasonableness of bias or real likelihood of bias, as despite the fact that the appellant knew all the relevant facts, he did not, before appearing for the interview or at the time of interview, raise even his little finger against the constitution of the selection committee. He seems to have voluntarily appeared before the committee and taken a chance of having a favorable recommendation from it. Having done so, it is not now open to him to turn around and question the constitution of the committee. Please. Having done so, it is not now open to him to turn around and question the constitution of the committee. This view gains strength from a decision of this court in Manaklal case, where in more or less similar circumstances, it was held that the failure of the appellant to take the identical plea at the earlier stage of proceedings created an effective bar of waiver against him. The following observations were made. It seems clear that the appellant wanted to take a chance and secure favorable report from the tribunal, which was constituted, and when he found that he was confronted with an unfavorable report, he adopted a device to raise the present technical point. Para 16. In Madan Lal versus State of J&K, similar views have been reiterated by the bench, which held that before dealing with this contention, we must keep in view of the salient feature that the petitioners as well as the contesting successful candidates, being respondents concerned, were all found eligible in light of the marks obtained in the oral interview, in the written for oral interview. Up to this stage, there is no dispute between the parties. The petitioners also appeared for the oral interview conducted by the members concerned for the commission, who interviewed the petitioners as well as contesting respondents concerned. Thus, the petitioners took a chance to get themselves selected at the said oral interview only because they did not find themselves to have emerged successful as a result of their combined performance, both the written test and the oral interview, they have filed this writ petition. It is now well settled that if a candidate takes a calculated chance and appears in the interview, then only because of the results of interview is not palatable to him, he cannot turn around and subsequently contend that the process of the interview was unfair and the selection committee was not proper constituted. In Om Prakash Shukla versus so-and-so, it has been clearly laid down by the bench that by the bench of 3 learned judges of this court that when the petitioner appeared for the examination without protest and when he found that he was not successful in examination, he filed a petition challenging the said examination. The High Court should not have granted the relief to such petitioner. Para 17. In Manish Kumar Sahi versus State of Bihar, this court reiterated the principle laid down in the earlier judgments and observed, we also agree with the High Court that after having taken part in the process of selection, knowing fully well that more than 19% marks have been earmarked for Viva test, the petitioner is not entitled to challenge the criteria of process of selection. Surely if the petitioner's name appeared in the merit list, he would not have dreamed or challenged the selection. The petitioner invoked jurisdiction under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. The conduct of the petitioner clearly disentitles him from questioning his selection, and the High Court did not commit any error in refusing to entertain the writ petition. 18. In Ramesh Chandra Shah versus Anil Joshi, recently a bench of this court, following the earlier decisions held as under, in view of the propositions laid down in the above judgments, it may be held that by having taken part in the process of selection and full knowledge that the recruitment was being made under the general rules, the respondents had waived the right to question the advertisement or the methodology adopted by the board for making selection, and that the single judge and the division bench of the High Court committed grave error in entertaining grievance and so on so. And accordingly, my lord, the matter was decided, my lord. So, my lord, the question here is, my lord, even though the petitioner had approached this honorable court earlier, my lord, but that challenge was, my lord, dismissed, and he did not challenge my eligibility then, my lord. It was just a, my lord, vague writ petition filed, and then pursuant to the dismissal of the writ petition, he has taken part in the this selection process. After being accepted,
his challenge in the first repetition was that the candidates did not fulfill the criteria.
Yes, my lord. Yes, my lord. Okay. And that petition was dismissed, my lord. Then he took part in the process, my lord. And in that petition, my lord, I was never made a party, my lord. It was only against the university. Now, my lord, after being unsuccessful, my lord, he now comes and challenges, my lord. In fact, if my lords goes through the merit, in case your lordships finds the writ petition maintainable, then also, my lord, from the records, your lordships will find that he is not successful, my lord. I am more qualified and I have been successful. That is my objection, my lord.
Yes, Mr. D.
My lord, there is an exception what my lord seniors has put forward, my lord. I am subject to correction by my lord senior, Mr. San. My lord, there is an exception. If the violation of the statute, Constitution of India, my lord, Article 14 and 21, 14, 16 and 21, my lord, then the writ is maintainable, my lord, and a quo warranto can be issued, my lord. I am challenging that quo warranto, my lord, can be issued, my lord. There is a judgment to the effect, my lord. Here, my lord, if a person who is not competent to sit in an office and he qualified, my lord, then a quo warranto can be issued, my lord. There is a judgment to that effect, my lord.
No, but please answer that point.
Yes, my lord.
Of person aggrieved.
Yes, my lord. How I am aggrieved?
Yeah, he just tackle a point they have raised first.
Yes, my lord. My lord, for this point,
within the 4 corners.
If my lord allowed me, my lord, I would like to place the facts first, my lord, before this honorable court. Then I want to go to the judgment, my lord, and then I will show, my lord, why this writ is maintainable, my lord. First, my lord, the facts has to be gone through, my lord. My learned seniors, they are trying their best, my lord, to kick me out on the maintainability so that dirty file will not be open, my lord. The selection chairman, I'm open to be corrected again, my lord, by my learned seniors.
Why are you saying dirty file?
Dirty facts, because, my lord, they are not even qualified to participate in the selection process. The screening committee forwarding those application, my lord, when they was very much aware that they was not qualified. The respondent number 6 and 7, they was not even qualified to participate. Let us see, my lord, respondent number 6. Respondent number 6 has said, my lord, the petition is not maintainable. But, my lord, can he show, my lord, that he has an experience of 10 years? He has obtained his UGC degree, my lord. Sorry, my lord, PhD degree.
Okay, just go back. What is the eligibility criteria?
10 years of experience, my lord. But here, my lord.
Experience in?
experience, my lord. After you are, you can apply for the post of professor from the assistant professor or associate professor, my lord. Now, when he become qualified for the post of assistant professor, my lord, he qualified when he obtained the degree of PhD, my lord. And when he has obtained PhD, 2015. Do he have that experience, my lord? He doesn't have the experience on the day of filing his application, my lord. I'm open to be corrected again, my lord.
The selections of which year?
Of 2022, my lord.
This selection?
Yes,
selection of this, the selection and second process took place in?
The advertisement was floated in, my lord,
16/3/2022.
22, my lord.
And when was selection process concluded?
Selection, my lord, they have given an appointment. September 23, my lord. So he lacked 10 years of experience, my lord. This is my understanding.
That is mandatory.
That is mandatory, my lord. And there is a requirement under UGC rules, my lord, UGC regulation. And that regulation has been violated, my lord. If my lord may kindly allow me to place the facts and the law in the next date, my lord, I will apprise this honorable court. I will place the facts, my lord, after lunch.
Yes.
And then I will show, my lord, why it is maintainable, my lord.
No, the only thing what he is saying is that dirty file. These are absolutely, my lord, casual and baseless submissions. And my lord, if he wants to go, I know what I want your lordship decide on maintainability. It has to be, my lord, decided on maintainability. Otherwise, your lordship, what he is saying, my lord, it sounds very impressive. 15 you obtain a PhD in 20 to how 10 years. It's not that easy, my lord. There are two kind of alternative qualifications, my lord. One is say teaching experience for 10 years. Another say, my lord, research experience, only on research. Not teaching.
Whether he has
that 10 years is not required. So that's a different thing, my lord. I am not going elaborately. That question will come, my lord, once he is through maintainability.
The question is, Mr. Day is seeking to substantiate his case first, by alluding to the facts. He says that will prove his case. So let him. My
lord, he can. But the thing is, what is the law, my lord? First threshold. You have to cross the threshold.
This court right now is concerned with the threshold.
Yes, my lord.
Whether he can
cross threshold, my lord. If he cannot cross the threshold, what the law say, my lord? Matter ends there.
That I will place the judgments on the next date, my lord. But the facts, I will place the facts, my lord. The entire facts, I will place it today. On the next date, my lord, I will place the judgments.
Otherwise, we will not take it that you place the facts on the judgment on the next date.
Then it's okay, my lord. My lord. Then let it come up on Monday, my lord.
Monday will take it up,
my lord. Why I said it is dirty, my lord, out of record, my lord, because the selection committee chairman, my lord, is in jail in a bribery case. He has been arrested by the CBI, my lord. That my learned friend can.
I don't know. Instead of going into all those things, making these kinds of baseless allegations.
This is not baseless. I have seen in a newspaper, my lord.
Absolutely uncalled for. Absolutely uncalled for. This kind of submission should not be made.
I am not submitted, my lord.
Unable to negotiate that how he will cross the threshold, my lord.
We will, my lord. We will definitely, my lord. We will definitely
do it first, my lord. Then you come.
All his advocacy skills to influence.
But there is a limit, my lord. Should not cross the limit.
That my lord will decide, my lord, whether I am crossing the limit.
I think, Mr. Sen, we are seasoned enough to separate the wheat from the chaff.
65.
Yes, next matter.
65.
Yes, for further hearing on. Mr. Day, you take your date Monday or Wednesday?
Wednesday, otherwise, my lord. This one. Next Wednesday, I will take my
better Wednesday because Monday is a bit heavy day.
My lord, I have no objection.
We'll give you enough time.
My lord, I will be prepared because I have to.
Come on Wednesday.
I have to. The authority
Wednesday,
in service matter, my lord. So I have to put my case in that.
Yes.
I please, your lordship. I'm praying for accommodation, lordship.
Where's the petitioner? You're a petitioner.
Yes, your lordship.
When?
After 1 week, lordship.
1 week.
Highly obliged.
Right, you inform your counsels.
Highly obliged.
Much obliged.
Yes.
66.
May I please, your lordship? I'm praying for the 1 week. Let the matter come up after the 1 week, lordship.
Why didn't mention in the beginning? What's the matter about?
Demarcation.
Demarcation is over.
Disputed things are there.
Mr. Sheikh, he is standing in attention out there. Where's Mr. Hazarika?
Yes, my lordship.
He's avoiding this case.
Yes, we had filed an affidavit saying that there are some disputes. So
no, he has to come up with instructions because
lordship, yes.
What happened was Ms. Hazarika is an allegation against him that he's obstructing the demarcation, correct?
No, that was in a different matter, Lordship.
Oh,
That
sorry.
was in a different matter.
Yes.
Okay, after 1 week.
Yes, my Lordship. Do you oblige, Lordship?
Tap the hot until 5 minutes. Yes.
67.
Yes.
This is a compassionate appointment matter, Your Lordship. I'm ready. I don't know the state.
Where's MS Ailingma? Don't pray for time, yes?
Yes. Lordship, 1 week, Lordship. I'll just.
Why?
I'll just.
You're the counsel appearing?
No, Lordship. Otherwise, I'll call her, Lordship. She is not available here, Lordship.
She's not?
So, she is not available in the court, Lordship. She might be in other court.
The last matter?
Yes.
Is argued before?
No, Your Lordship. This is the first time the matter has come up for hearing.
When was the application made? Before 2011?
2008, Your Lordship. My first application was made in 2008. It was rejected in 2012. Then I made another application in 2018.
Yes, you start meanwhile.
May it please Your Lordship. Your Lordship, this matter pertains to compassionate appointment, Your Lordship. My father died sometime in the year 2008, Your Lordship, 7th April 2008. While he was in service, Your Lordship, leaving behind the petitioner and the petitioner's mother, and four of my siblings, Your Lordship.
Yes.
Lordship, in the
Where is the matter?
Your Lordship, I'm looking for some accommodation
Why?
today, Your Lordship. The leading counsel, Mr. SN, is currently not available.
Who's here in the case then?
Mr. SN is. I'm the assisting counsel, Your Lordship.
They should inform the.
I've
Should inform
mentioned
the
in the
police
morning.
counsel.
I've mentioned in the morning, but he was not
After
there.
1 week, we'll take a fixed matter. Yes. On the request of MS Ailingwa, due to absence of counsel, this matter after 1 is a fixed matter. I don't do adjourn matters like this actually. Yes. Hello.
Obliged, Lordship.
Jai Jai Ram Sahib.